welcome to the firm. On the show this week, to e-vote or not to e-vote, confusion, corporate India and the Corporate Affairs Ministry. And 5 big changes suggested by the Sahoo committee to revitalise the depository receipt route. This week, the Ministry of Corporate Affairs deferred the mandatory e-voting provisions of the Companies Act 2013 to next year. Now, if you've been watching the Companies Act series, you'd be aware of the confusion that has caused the MCA to do this. If not, here's how you can get up to speed. Section 108 and the accompanying rules of the new company law allow shareholders of all listed companies and companies with at least 1,000 shareholders to vote electronically. A detailed process for e-voting is laid down in the rules, including that the e-voting portal must be closed 3 days before the shareholder meeting. But a prior section in the law, that is section 107, is worded to imply that if a resolution has been voted upon electronically, then it cannot be put to vote by a show of hands at the shareholder meeting, which is commonly how resolutions are voted upon in meetings. Now, this unfortunate wording has led to considerable confusion, and that confusion finally caused the MCA to respond by postponing the problem to next year. But SEBI has not yet deferred e-voting requirements under clause 35B of the listing agreement. So listed companies may still need to offer e-voting facilities. Add to that a recent Bombay High Court decision that suggests that e-voting should be offered at meetings as well. How did a facility meant to encourage more shareholder participation become so confusing? Joining me to discuss this existential crisis, to e-vote or not to e-vote, is Sanjay Asher of Crawford Bailey. Sanjay, thanks very much for joining me. The MCA says, look, don't worry about e-voting, we've pushed it to next year. But SEBI's clause 35B, which also relies on the Companies Act 2013 and its rules, says e-voting applies to both postal ballot resolutions as well as meeting resolutions, and that is effective now and has not been deferred. So does that mean that this deferment of e-voting applies only now to unlisted companies with 1,000 shareholders or more?
Absolutely.
And does not apply to listed companies?
Absolutely, because all listed companies will necessarily have to comply with the provisions of listing agreement, and therefore comply with 35B. And 35B says that every resolution which has to be placed before a general meeting or which has to be done by postal ballot necessarily have to be done by e-voting.
So,
and that too under the company management and administration rules of 2014.
Yeah, so that's interesting because the language in 35B does link to the rules of the Companies Act, right?
Yeah.
And if the MCA, which is the parent of the Act and the rules, is deferring the rule that applies on e-voting by 6 months, then automatically clause 35 would not get deferred, or would you wait for an explicit announcement from SEBI saying we too are deferring?
I would wait for an explicit announcement from SEBI to that effect,
okay,
because it only says in a manner and in accordance with the provisions of company management and administrative rules. So the procedure to be followed is under the company management.
So it only relies on the rules for the procedure,
absolutely,
not for the actual application of e-voting.
Not for that.
But there are two interpretations to the SEBI position as well, right? Because SEBI has used slightly different wording in
the draft
previous circulars and the new approach paper that it has put out with regards to a listing regulation.
Absolutely.
Where it links e-voting only to postal ballot and not to general meetings.
Absolutely.
How would you interpret that?
Because if you see July 13, 2012 circular, which was the starting point,
or the May draft paper,
which converts the listing agreement into listing regulations, it only speaks about the items which have to be done at the postal ballot.
Right. In compliance with section 108 and 110 of the Companies Act 2013 and any other rules made there.
That's correct. That's correct. Whereas the existing 35B speaks about the items which have to be dealt at the general body meeting or through the postal ballot.
So these are two different things, because SEBI currently seems to be saying under the existing 35B that you must make e-voting available for both resolutions put to vote under postal ballot and resolutions put to vote at a shareholder meeting. Right?
That's correct.
But in previous circulars and
only
in the approach paper, it seems to link e-voting only to postal ballot resolutions.
Absolutely.
So what do you think applies to companies right now? The prevalent 35B, or would you go by the language that existed earlier and the language that is likely to come?
I would say the prevalent 35B, because that is what the statute is. We can't say that because the draft regulations say they are in draft form.
Okay,
And
but there seems to be some confusion. People are taking both interpretations, saying, no, but SEBI doesn't really mean general meeting, it only means postal ballot because of its previous circulars and because of the forthcoming regulations.
There's no clarification to that effect by SEBI to that.
So the current 35B stands.
Absolutely.
Which means all listed companies, now this is where we say, all listed companies have to offer e-voting with regards to postal ballot resolutions as well as resolutions to be voted on in a meeting.
Body meeting. Yes.
Okay?
Yes.
Now we come to how does that voting happen in a meeting. So if listed companies are to provide e-voting, it means according to 107 that they cannot allow for a show of hands to take place at the meeting.
Yes.
Right? That's the interpretation broadly everybody's taken of 107.
Yes.
Which means that all resolutions to be passed at the meeting have to either be passed on the basis of only the e-votes or on the basis of polls. Which one? Or the combination of both?
Yeah, but a poll is demanded only after a show of hands. Yeah, after a show of hands. 109 says that only after the show of hands that a poll is demanded.
No. So if 107 says if you e-vote, you cannot do a show of hands.
You cannot do show of hands.
Which means you can either only count the results of the e-voting or you do to pass the resolution through polls and combine the outcome of the polls with the e-voting outcome and come to a final decision on the resolutions. You're saying you can't even do the polls.
Yes, we can't do a
because
poll.
Because 109 says before a poll happens, a show of
hands happens.
But that's a slightly extreme interpretation, isn't it?
No, but that is what the law is, to my mind. Because even under the old statute as also under the new statute.
No, but that would mean effectively, Sanjay, that you would go to a meeting and do what? Eat samosas.
No, the management will explain the items which are there.
You can't vote through a show of hands.
Yes.
You're saying you can't vote through a poll.
Yes.
That's bizarre.
Yeah, then
can't the chairman call for a poll? The chairman
can call for a poll, of course. But then the Bombay High Court judgment comes into play in the Godrej case, where the Bombay High Court has said that you provide e-voting facility at a meeting.
Yeah, but we've just seen companies do that.
Yes, which goes beyond what the law says. But then if the Bombay High Court is interpreted to say that, look, please have the e-voting facility, which is why some companies have adopted that and are doing a poll through the tablet mechanism or similar mechanism.
Karbi is just offering that as a product. They're selling that to AGM, saying, look, you can now, instead of doing polls through paper slips, you know, and going through every resolution and then collecting the slips into the ballot box and etc., just do it electronically. But it's not exactly e-voting because the e-voting portal is shut 3 days ago. So it's now poll, but it's an electronic poll.
Electronic poll.
So we have an e-vote and we have an e-poll.
Yeah, but the question still remains as to whether you can have a poll when you have already done an e-voting.
But wouldn't you say that, well, I understand that you're interpreting the law strictly by the words, but there are some who believe that there is enough foreign jurisprudence to show that you cannot deny a shareholder the opportunity to vote simply by way of this kind of procedure, saying, no, but if there's no show of hands, you cannot call for a poll, because then you're denying him his voice altogether, right?
True, there are passages in Palmer, Gower, Pennington which speaks about that you don't deprive the shareholder from doing an electronic voting or a voting at a poll, although the law does not mandate that.
Yeah.
But that's one way of looking at it.
So very few companies would take the extreme interpretation of 109 as you have taken.
That you
they would be really rubbish companies to do that.
No, not rubbish companies to do
Even if it stands up in a court of law strictly, it would be fairly rubbish to deprive the shareholder who's attended the meeting the opportunity to vote because of some technicality in the language of the law.
I'm only saying that one is the strict interpretation of law. The other one is that governance point of view. If you want an absolute democracy in the shareholders meeting, then surely, even though you have closed your electronic vote 3 days prior to the date of the meeting, please offer this facility of voting through a tablet or do a poll.
Don't confuse the e-poll with the e-vote.
No,
because the e-vote rules say you have to shut the portal 3 days before.
So you've done that already.
This is an e-poll, not an e-vote.
Yeah, e-vote, so you've already done that. Now, at a meeting, the shareholders who are attending the meeting, please give them the facility to vote through poll mechanism. And that poll mechanism...
So most people will interpret 109 to mean that. The chairman will order, saying, since I can't do a show of hands because of the way 107 is worded, I'm going to pass all these resolutions through a poll.
Yeah,
and you can vote using a tablet.
Yeah, that's a safer view. That's more from a governance point of view. And in these days of corporate governance, yes, that's a better way of doing it.
But some companies can take shelter under the interpretation of 100.
Can take shelter, but at the same time, the better way of doing it is complete your e-voting and then again do a poll at the general body meeting.
Through an electronic
Yes.
format or through paper slips, whichever one you
Yes.
prefer. Now, in fact, these two would be more synchronous, because the problem with trying to synchronize e-voting results with a show of hands results would be that e-voting is one share, one vote.
Yes.
Show of hand is one person, one
vote.
Right? So actually, there is a silver lining to this since show of hands has gone out of the window, and you are now forced to do all of this through polls. Polls are also one share, one vote.
Yes.
E-vote is also one share, one vote.
Yes.
So the two are synchronous, and therefore the
Absolutely.
combined outcome makes more sense than to
Absolutely.
try and combine the outcome of e-voting and show of hands.
Yes,
So there is a silver lining to
There
this
is silver
cloud.
lining.
Okay.
Absolutely.
So what happens for scheme meetings is the only other question.
Yeah,
that I
then in which event the show of hands do come in play, because it says majority in number representing 3/4 in value. So only in scheme meetings
will you have to have a show of hands?
show of hands. Otherwise, for rest of the meetings, in case of listed entities, show of hands go by the wayside.
Yeah, actually you can have a majority. You don't even need a show of hands. For majority in number, you can still create an electronic poll of sorts, whereby you have two different votes. You're casting two different votes. You're casting on the behalf of your shareholding as one,
Yes.
to meet the 75% requirements, and you're casting to be part of the numerical majority as one, right? So you could
Yes,
do
so
that through a tablet, and it can be done
Yeah, whether-
simply, or tablet or paper slip or whatever,
Yeah,
right?
that is the
So
practice
show of
which is
hands is
followed.
dead forever now.
Yes.
All right, Sanjay, for now we'll leave it there. The MC has also issued some clarifications along with that deferment circular, but many of those clarifications are very confusing. So hopefully they've got some time with this deferment up to this December 31st, and will clarify the clarifications so that we know once and for all what the e-voting procedures are meant to be. Sanjay, thank you very much for joining us on the firm. With that, we head into a quick break. Coming up on the other side, 5 big changes suggested by the Sahoo committee to revitalise the depository receipt route.